Welcome to the video. Today we unpack why visiting the United States on a B-2 tourist visa while you have a pending or approved immigrant petition is commonly denied under U.S. immigration law, the role of Section 214B, why expedite requests rarely work, and what you can realistically do. We will also include a disclaimer that this is not legal advice and provide a few quizzes along the way. Here is the agenda. First, we will set the context and big picture. Next, we will present an essential disclaimer. Then we will distinguish immigrant intent from non-immigrant intent. After that, we will explain 214B, denials. We will compare expedite standards versus reality, cover risks of applying for a B-2 while waiting, review practical steps, and finish with key takeaways and a summary. Disclaimer. This video is for general informational purposes only and does not constitute legal advice. Immigration laws and policies can change, and individual facts matter. You should consult a qualified immigration attorney for guidance on your specific case. To set the stage, many people wait years for family-based immigrant visas and naturally want to visit family on a B-2 visa during the wait. However, U.S. law requires B-2 applicants to prove non-immigrant intent, meaning they intend to return home after a temporary stay. If you have an immigrant petition pending, the U.S. views you as an intending immigrant, creating a conflict. This conflict drives many denials. Non-immigrant intent means you must prove you will return to your home country after a temporary visit, supported by strong ties like employment, property, and family. Immigrant intent means you plan to live in the U.S. permanently. A pending or approved I-130 identifies you as an intending immigrant. Because the B-2 category requires non-immigrant intent, having an I-130 in process often creates a direct conflict, resulting in denials under Section 214B. This flowchart visualizes the decision path a consular officer might consider. Starting from whether the applicant has a pending or approved I-130, if the answer is yes, the officer evaluates whether there are exceptionally strong temporary ties and a compelling temporary purpose. In most such cases, the conflict with immigrant intent leads to a likely 214B denial. If there is no pending immigrant petition, the applicant goes through standard B-2 criteria, where approval depends on demonstrating sufficient ties and a credible temporary visit. The end states contrast likely denial with the rare case of approval despite immigrant intent, emphasizing that such approvals are uncommon. Section 214B is the part of the law under which an applicant is refused if they cannot establish non-immigrant intent. Officers examine databases to see if an immigrant petition is pending or approved. If it is, the officer often concludes the applicant has immigrant intent and cannot meet the B-2 standard. The trust in temporary intent is undermined, leading to a quick 214B refusal in many cases. Here we compare common myths to the underlying realities. Emotional appeals rarely overcome statutory intent requirements. A short proposed trip does not resolve the immigrant intent conflict. A personal promise to return is insufficient without evidence of strong ties. Prior visas or travel history do not guarantee approval, because each application is evaluated anew, and a pending immigrant petition significantly alters the analysis. This table outlines common expedite categories. National interest cases and true humanitarian emergencies, like life or death medical crises affecting the petitioner or the principal applicant, may qualify. General family separation or emotional hardship typically does not. Non-life-threatening illnesses are also unlikely to meet the standard. The Visa Bulletin priority date queue is almost never bypassed, so position in line remains controlling. This timeline illustrates the family-based immigrant visa journey. A priority date is set when the petition is filed. There is often a long waiting period before the category becomes current in the Visa Bulletin. Once current, the case moves through NVC processing to become documentarily qualified, then to a consular interview, followed by visa issuance and entry to the U.S. as a permanent resident. Expedite approvals are rare. The queue position largely controls when each step occurs. Applying for a B-2 while an immigrant petition is pending carries significant risks. Denial under 214B is common. The refusal becomes part of the permanent immigration record and may complicate future applications. Applicants from regions with higher overstay concerns often face even more scrutiny. There are financial and emotional costs. Although rare approvals do occur, they are exceptional and cannot be relied upon. The pie chart is illustrative only and does not represent actual statistics. Quiz time. Question: which statement best explains why B-2 applications are usually denied when an I-130 is pending? Option A: because B-2s require non-immigrant intent, and a pending I-130 signals immigrant intent. Option B: because B-2 visas are currently suspended worldwide. Option C: because officers cannot verify financial documents. Option D: because prior travel automatically voids new applications. You may pause the video now to think about the answer. We will discuss the answer in the next section of the video. The correct answer is the first option. A pending or approved immigrant petition identifies you as an intending immigrant, which conflicts with the requirement to prove non-immigrant intent for a B-2 visa. Instead of focusing on a B-2 visit, work on strengthening ties to your home country with evidence such as employment, property, education, and tax records. Prepare early for your immigrant visa interview by gathering civil documents, police certificates, and financial support forms. Monitor your priority date and category in the Visa Bulletin. If feasible, consider meeting family in a third country that does not require a U.S. visa. If a true humanitarian emergency arises, document it thoroughly for a potential expedite request, though approvals are rare. Finally, manage expectations and your mental well-being, recognizing the process may be lengthy. Here is a quick Markdown recap of the core concepts. Non-immigrant intent versus immigrant intent. Section 214B, as the legal standard for refusal when non-immigrant intent is not established, and the practical focus on preparing for the immigrant visa instead of attempting risky B-2 applications while a petition is pending. Second quiz. Which expedite scenario is most likely to be considered? Option A: general emotional hardship due to years of separations. Option B: life or death medical crisis involving the petitioner or principal applicant. Option C: recovering from a routine surgery. Option D: a letter from an employer requesting faster reunification. You may pause the video now to think about the answer. We will discuss the answer in the next section. The correct answer is life or death medical crisis involving the petitioner or the principal applicant. That is a genuine humanitarian emergency that may warrant expedite consideration, whereas general separation or non-critical medical issues are unlikely to qualify. Key takeaways. The B-2 visa requires non-immigrant intent, which conflicts with an I-130 petition that shows immigrant intent. This often leads to 214B refusals. Expedite approvals are rare and generally limited to national interest or true humanitarian emergencies. Applying for a B-2 while waiting is typically risky and counterproductive. The best strategy is to accept the timeline, maintain strong ties abroad, and prepare for the immigrant visa process. In summary, once an I-130 exists, the system treats the applicant as an intending immigrant. Because non-immigrant intent is required for B-2 visas, this creates a conflict that often results in 214B denials. Expedite options are narrow and exceptional, so most movement is determined by the queue. Applicants should invest in preparation and personal resilience during the waiting period. Thank you for watching. If this video was helpful, please like, share, and subscribe. We would love to hear your questions and experiences in the comments. Your feedback helps others in similar situations and guides future videos.